Welcome to the video tutorial Insolvency. This short tutorial has been prepared to provide you with background information on the financial and legal concept of insolvency. The following topics are addressed: insolvency concepts, insolvency law, insolvency proceedings, illiquidity, imminent illiquidity, over-indebtedness, illiquidity and over-indebtedness, wrongful and fraudulent trading. The video tutorial will be concluded by an imprint. What are the two major insolvency concepts? This unit will briefly introduce the insolvency law framework. Insolvency law is a complex field of law with correspondingly diverse financial implications. Therefore, only selected aspects will be dealt with in this unit. The term insolvency includes two fundamental and important financial and legal concepts: illiquidity and over-indebtedness. Illiquidity is also called inability to pay or cash flow insolvency. The concept of illiquidity addresses the problem of insufficient liquidity. Over-indebtedness is also called a debt overload or balance sheet insolvency. The concept of over-indebtedness addresses the problem of liability, meaning the ability to cover debts or the debt coverage capacity. The concepts of insolvency and over-indebtedness always presuppose the existence of a creditor-debtor relationship. What is regulated in insolvency law? In countries with developed legal systems, insolvencies are regulated in insolvency law. In the context of this unit, German insolvency law is used as an example. The central source of standards in German insolvency law is the German Insolvency Code, which regulates insolvency proceedings. It serves to jointly satisfy the creditors of a debtor. The principle of equal treatment of all creditors, also known in Latin as par conditio creditorum, is applied. In essence, insolvency proceedings offer two options. In liquidation, the debtor's assets are realized and the proceeds distributed to the creditors. In the case of restructuring, a different arrangement can be made within the framework of an insolvency plan, in particular to preserve the company. The explanations in this unit are limited to corporate insolvencies. The so-called consumer insolvencies or insolvencies of natural persons or private households are not considered. What are the requirements for insolvency proceedings? The German Insolvency Code states clearly, the opening of the insolvency proceedings presupposes that there are grounds for opening them. The Insolvency Act lists 3 reasons for opening insolvency proceedings. The first reason for opening insolvency proceedings is illiquidity. Section 17 of the German Insolvency Code states, the general reason for opening insolvency proceedings is illiquidity. The applicability of Section 17 of the Insolvency Code applies to both natural and legal persons. The obligation to file an application lies with the debtor. The law also provides for a right of application for the creditor. The second reason for opening insolvency proceedings is the so-called imminent illiquidity. Section 18 of the German Insolvency Code states, if the debtor applies for the opening of insolvency proceedings, the imminent illiquidity is also a reason for the opening of proceedings. The applicability of Section 18 of the Insolvency Act applies to both natural and legal persons. There is no obligation for the debtor to file an application. Rather, Section 18 only provides a right of application for the debtor. There is no right of application for creditors. The third reason for opening insolvency proceedings is over-indebtedness. Section 19 of the German Insolvency Code states, in the case of an illegal entity, over-indebtedness is also a reason for opening insolvency proceedings. Section 19 of the Insolvency Code shall apply only to legal persons. The obligation to file an application lies with the debtor. In addition, the law again provides for a right of application for the creditor. How is illiquidity defined? In this unit, we will first look at the reason of illiquidity for opening insolvency proceedings. Section 17.2 of the German Insolvency Code defines the term as follows. The debtor is illiquid if he is not able to fulfill the payment obligations due. Illiquidity is usually assumed to assist if the debtor has suspended payments. This definition, which initially appears clear and absolute, has occasionally led to problems in operational practice. If the first sentence had been interpreted very narrowly and literally, even a very short-term payment hold-up that was resolved the very next day would have led to a reason for opening the proceedings with a corresponding obligation to apply. Since it can hardly be in the interest of the law that otherwise economically sound companies file for insolvency, a certain scope for assessment had already developed in the past in insolvency law practice. The Federal Court of Justice then logically further specified the concept of insolvency in its case law. Accordingly, there is no illiquidity in the case of delayed payments and insignificance. A delayed payment can be assumed if there is a well-founded assumption that the total or partial inability to pay can be cured within 3 weeks. In some cases, there are payment delays because companies themselves have to wait for the receipt of outstanding payments. The 3-week period is intended to enable a debtor to collect his own outstanding payments or at least to clarify their status. In addition, or alternatively, a defaulting debtor should be able to raise further equity or debt capital within the 3-week period in order to meet his payment obligations. Negligible is the case if the liquidity gap does not exceed 10% of the liabilities due. A timeline is provided to illustrate the factual situation resulting from this. If there is a payment hold-up, the company must check after 3 weeks at the latest whether the 10% limit has been adhered to. If the 10% limit is exceeded, the company must file for insolvency after 3 weeks at the latest. How is imminent illiquidity defined? In this unit, we will look at the opening reason of imminent illiquidity. Section 18.1 of the German Insolvency Code regulates this. If the debtor requests the opening of insolvency proceedings, the imminent illiquidity shall also be a reason for the opening of such proceedings. With the concept of imminent illiquidity, the legislator is pursuing a specific purpose or objective. The purpose is to protect the debtor from his creditors. He should be given time to avoid the final illiquidity. The objective is thus to enable financial restructuring or reorganization within the framework of court-assisted insolvency proceedings. This raises the question of how an imminent illiquidity, and thus the reason for opening insolvency proceedings, can be proven. Section 18.2 of the German Insolvency Code defines the term imminent illiquidity as follows. The debtor is at risk of becoming illiquid if he is presumably not able to fulfill the existing payment obligations at the time of maturity. The debtor must provide evidence that he is likely to be threatened by illiquidity. This proof can be provided by a short to medium term liquidity or financial plan. How is over-indebtedness defined? Section 19.2.1 of the German Insolvency Code stipulates this. Over-indebtedness exists when the debtor's assets no longer cover existing liabilities. The definition thus implicitly ties in with the fundamental accounting equation. Assets are equal to equity plus debt, or assets minus debt are equal to equity. This means that if the assets are lower than the liabilities, then the equity is lower than 0. This connection can also be illustrated by a balance sheet. The starting point here is a balance sheet in T0, which can be roughly divided into the blocks of assets, equity, and debt. If a situation now arises in which sales-related or valuation-related losses can no longer be covered by equity, a deficit arises. In the balance sheet in T1, this deficit is shown on the assets side as negative equity. How do illiquidity and over-indebtedness relate to each other? Occasionally, the term over-indebtedness is used inaccurately and confused with the term illiquidity. In this context, the following note is important. Over-indebtedness can, but does not have to go hand in hand with illiquidity. This can be seen in a more detailed breakdown of the balance sheet in T1. On the assets side, the assets were roughly divided into the blocks other assets and cash. It is possible that cash is sufficient to cover the payments due. Nevertheless, due to the absolute amount of assets in relation to debt, there is an over-indebtedness in the balance sheet. 4 possible scenarios or financial conditions for a company can be derived from these considerations. A company is not over-indebted and not illiquid. B. A company is not over-indebted but illiquid. C. A company is over-indebted and illiquid. D. A company is over-indebted but not illiquid. The letter case D is represented here by our balance sheet in T1. Why is it important to observe insolvency law? It serves the protection of the general public as well as the business partners of a company in particular that an application for insolvency is filed in the event of insolvency. In the event of an insolvency, the continuation of the company's business activities can deteriorate the situation. If the liquidation is delayed, existing creditors could be even worse off. The law, therefore, makes it a punishable offense to enter into obligations if one of the reasons for opening insolvency proceedings exists. Non-submission or failure to submit an application for insolvency within the prescribed period is also referred to as a delay in filing for insolvency. By definition, according to Section 15a(4) of the German Insolvency Code, a delay in filing for insolvency exists if a request to open insolvency is not filed correctly, or not filed on time. As direct consequences, prison sentences of up to 3 years or fines are possible. Even in less serious cases, that is, in cases of negligence, prison sentences of up to 1 year or fines can be imposed. In the event of a final and absolute conviction, a further consequence of the German Limited Liability Company Act is a 5-year blocking period for the appointment as managing director of a limited liability company. According to the German Stock Corporation Act, the consequence of a conviction is a 5-year blocking period for the appointment as executive board member. In the case of a prison sentence, the blocking period does not begin until the prison sentence has been served in full. The German Criminal Code lists further insolvency offenses which can be punished with several years imprisonment depending on their severity. These include bankruptcy, fraudulent bankruptcy, breach of the obligation to keep accounts, favoring creditors, and favoring debtors. The insolvency law implications outlined in this unit are another reason why studying finance is of great practical value.